On behalf of Judge Stafford and Judge McGee, we are pleased to welcome Mr. Tootin, Mr. Welford, and Mr. Joy, counsel for the three parties in this appeal. Before we hear the oral argument, the panel wishes to address the motion filed yesterday by Mr. Tootin as attorney for the plaintiff and appellant to withdraw. The motion says that he received a handwritten note from his client, and I'm going to quote the handwritten note, which you can't really see on the screen, but it's dated October 29, 2020, to attorney Terrell Tootin. I, Mr. Arthur Lee Woods, no longer need you to represent me on my medical malpractice case against Methodist University, signed Arthur Woods. And Mr. Wooten, your motion mentions that you received this from another law firm that your client has contacted. When did you first receive this October 29 handwritten note from your client?
Your Honor, that's attached on the printout of the email. I received that on November 16, 2020. It was the message, it was sent at 11:56 a.m.
All right,
that law firm included that.
All right, so you literally received this instruction from your client yesterday and not before yesterday?
Absolutely, yes.
All right, very good. And is your client aware that the oral argument is scheduled to occur today at 3 o'clock?
I know that. I've made the law firm aware. I've tried to call my client on the numbers he had given me, and there was one number that it actually rang and there was no answer. And then there were the other numbers. And the number, let me say this, the number that rang and was no answer was not my client's phone number, but it was a number my client had called me from before. So I tried it. The numbers that were related to my client, my calls did not go through. They did not, I was not able to get a connection to, I don't know if the phones were disconnected or whatever the case may be, but I was not able to get an opportunity to either get a dial tone to speak to someone or anything of that nature.
Was your client aware on or before October 29 when he wrote this note that his case was going to be heard by the Court of Appeals on Tuesday, November 17th?
I do not know if he was aware of the day. He knew that we had oral argument that was going to occur, and that he wanted, when I last spoke to him, he said, just let him know how things go. But as far as to answer the court's question directly, I can't represent to the court that he personally, we've ever had a conversation that says on this date, on this time, your oral arguments are now set. Like I said, I know that was communicated to the firm, but I can't say I was ever said that to the client.
Thank you. So he knew that the case was set for oral argument and it would be soon, but he did not necessarily know it was today or at 3 o'clock today.
Yes, to my knowledge, I can't say he knew that.
Has your client or this law firm which contacted you yesterday on his behalf asked that this oral argument be continued?
No, and what I will say is further than that is after filing this motion, I continued to reach out to the law firm. The first time I got in touch with the individual named on the email, they basically, they said something to the effect that the person I was speaking to was an administrator, apparently not an attorney. They said, well, we'll let the attorney know, they'll get in touch with you, and then we'll just deal with it from there. So then at about, I want to say around 4:30, I emailed them again and asked, are you filing the notice of appearance today? What are you doing? And the response was, no, not today. We may not take this case. We didn't know that the lawsuit was even filed or something to that effect. I can read it, the direct email if that's necessary, but that did happen around 4:30 yesterday is when I got that last correspondence from them.
Very good. Thank you, sir. Before we hear from the other attorneys, Judge Stafford and Judge McGee, do you have any additional questions of Mr. Tootin?
No.
Think so.
All right. Mr. Welford and Mr. Joy, you don't have a voice in whether we grant the motion to withdraw, but you do have a voice in whether we should go forward with the oral argument with only the two of you speaking on behalf of the appellees, or whether we take it, or whether we allow the case to proceed, but instead of via oral argument, we take it up on brief. So I would like to hear from each of you, and you can decide who goes first.
Your Honor, this is Mr. Welford, and I'll go first on behalf of Methodist. We do ask that the case go forward with oral argument from the appellees. We prepared for the oral argument. The court considered it appropriate for oral argument. And so we think we would be potentially prejudiced if we didn't have an opportunity to make the oral argument.
Thank you, Mr. Welford. Mr. Joy.
Good afternoon, Your Honors. Justin Joy here on behalf of Drs. Arthur and Sorensen. Same position. We too believe that this matter should proceed this afternoon based upon the information that we've been presented with.
Thank you, Mr. Joy, Mr. Welford, and Mr. Tootin. Judge Stafford and Judge McGee, do either of you have any questions of counsel?
I would like to ask Mr. Welford, Mr. Joy, do you have any information that would help us in considering the motion to withdraw filed by Mr. Tootin? Anything that we're not aware of that we should be aware of?
I do not, Your Honor, speaking on behalf of Methodist.
And nor do I, Your Honor.
Right.
All right. Thank you. Judge McGee?
No.
All right. Very good. Then all three counsel, if you will stay online, and please understand that this will continue to live stream. So don't say or do anything that you wouldn't want the world to see or hear. The three judges, we will electronically disappear and to go into a private conference chamber, and we'll be back shortly. Mr. Morgan, would you please make that happen? All right, I believe we have everybody back. I'm looking for all the Hollywood Square boxes. And first, I want to thank Mr. Tootin, Mr. Welford, and Mr. Joy for their comments, and particularly Mr. Tootin for your willingness to answer our questions. Having considered the matter in chambers, the court has decided to grant Mr. Tootin's motion to withdraw as counsel for the appellant, which is effective immediately. We have decided to proceed with the oral argument because the appellant was aware the case was set for oral argument when he chose to dismiss his attorney, and no motion to continue has been filed. Thus, there's no justification in our view to not proceed with the oral argument. And we will hear from Mr. Welford and Mr. Joy on behalf of the appellees. Mr. Tootin, if you wish, you may stay on the line and observe, or since you are no longer counsel for the appellant, you may withdraw. We'll leave that up to you, but we will not be hearing from you. All right, the appellees have a total of 15 minutes to present their arguments. Mr. Welford, how much of that would you like?
Your Honor, we've agreed that Methodist will take 10 minutes and the physician defendants will take 5.
Excellent.
Could I interject? I'm sorry.
Yes, sir.
We have someone trying to intervene in this case, and I don't know if it might be the appellant's new lawyer or what. How do you want me to address that?
To my knowledge, no one has made an appearance or entered a notice of appearance, and so I see no reason to allow anybody to join in the oral argument, but they are permitted to watch it on the YouTube channel of the Administrative Office of Courts and/or to observe it at a later date, realizing it will be posted. But thank you, Mr. Hibner, for bringing that to my attention.
Yes, Your Honor.
All right, please call the case, Mr. Hibner.
Arthur Woods versus Adam Arthur, MD, et al.
Thank you, Mr. Hibner. And this case is proceeding with oral argument, as we just announced, after having heard from the appellant's now former attorney, and who will not be participating in the oral argument. And the appellant has not made an appearance or requested the right to represent himself today, and no one else has entered a formal notice of appearance on behalf of the appellant. Therefore, we will hear from Mr. Welford first on behalf of the Methodist defendant. Mr. Welford, the floor is yours.
Thank you, Your Honor. May it please the court. My name is Buckner Welford and represent the defendant appellee, Methodist Le Bonheur Healthcare. We've noted for purposes of the brief that the appropriate name should be Methodist Healthcare Memphis Hospitals, but it doesn't affect anything substantively that we're making in this argument. We believe in this case that it is clearly governed by the principles that were first set forth by the Tennessee Supreme Court in Stevens v. Hickman Community Center, and then later reaffirmed by the Tennessee Supreme Court more recently in Martin versus Rolling Hills, and which has since been reaffirmed in at least 3 Tennessee Court of Appeals cases since Martin, of which we are aware, with a fairly simple set of pertinent facts that were presented. The case does have a somewhat tortured procedural history, but we don't think that takes anything away from the basic simplicity of the facts. Specifically, there were several technical violations of the pre-suit notice statute that occurred in this case, but we focused only upon those that raised the substantial compliant standard that is set forth in TCA 2926 121A2. As an example, the plaintiff appellant did not file an affidavit of compliance with the complaint, but later cured that, and then in the process of curing it, attached some medical, some HIPAA authorizations, which were not included in the original or attached to the original complaint. We preserved our defenses, but didn't seek to prove or disprove whether those revised authorizations were in fact delivered. We instead have assumed for purposes of the record thus far and here that those revised HIPAA authorizations were in fact sent to the defendants, including Methodist, and we still consider them to be deficient, as did the trial court. The issues that we identified focused on the fact that 4 different providers in this case received pre-suit notice. We were entitled to to complete records. It's sometimes described as relevant records for 3 of those providers concerning surgeries that were performed in October 2016 and January of 2017 at Methodist University Hospital. What Methodist received was a defective form for 2 of the 3, a form that did not specifically include the purpose of the disclosure, which is a core element and has been held in the Parks versus Walker case to be in and of itself enough to make the HIPAA authorization defective. And Methodist received no authorization at all, allowing it to see whether there were medical records maintained by the 4th provider, Dr. Lingo, and if so, what those records would have shown. Under the circumstances, it was under the Martin standard, it's clear that the HIPAA authorizations did not enable Methodist to receive a benefit to which it was entitled under the statute. It did not allow Methodist to perform an important investigatory function of seeing what might be in relevant medical records pertaining to these surgeries that were performed and described in the pre-suit notice and later in the complaint. And that under those principles, there's at least a rebuttable presumption that Methodist has been prejudiced by that. Burden then shifted to the plaintiff to demonstrate that Methodist had not been prejudiced by the lack of the ability to do that. The plaintiff did not carry that burden in the trial court and did not carry it or explain sufficiently in the brief a reason why this court should reverse the trial court on her ruling that as part of the substantial compliance standard, the plaintiff did not demonstrate that Methodist was not prejudiced by the defective authorizations. It is the plaintiff's burden and not ours to demonstrate the prejudice, and they failed to carry that burden. There were actually other technical deficiencies in the notice that Methodist received. It did not list, which is a core element, the notice that Methodist received allowing it to obtain records to whom Methodist was entitled to disclose records. But we have not relied upon that on appeal because there was a separate authorization that was sent to Drs. Sorensen and Arthur, and we did not make that a basis for the appeal. But we have focused on the important elements of what we think the case law emphasizes, which is the ability to obtain records that allow us to investigate the nature of and the basis for claims that could have been asserted against Methodist. And being unable to receive those, we think that the trial court correctly found that there was no substantial compliance in this case and that the dismissal was warranted under the circumstances. I'll note that the plaintiff identified as an issue only the dismissal of the case. And so that's the issue that we focused upon in the briefs and I'm focusing upon here. With that, I have no further prepared elements of the argument, but would be happy to respond to any specific questions that the court might have.
Does anybody on the panel have any questions of Mr. Welford? Hearing none, we'll now hear from Mr. Joy.
Thank you, Your Honor. Good afternoon, and may it please the court. I'm Justin Joy here on behalf of the defendant physicians, Adam Arthur and Jeffrey Sorensen. As stated in our brief, this court has consistently upheld dismissals by trial courts where deficient medical authorizations, such as those at issue before this court, resulted in the inability of the parties receiving the pre-suit notice to obtain medical information as provided in Tennessee Code Annotated 26-121 from the other providers receiving the pre-suit notice. The same result, affirming the dismissal, should occur here. Similar to Methodist, Doctors Arthur and Sorensen were prejudiced by the plaintiff's noncompliance. Specifically, these doctors were deprived of their right under Tennessee law to obtain a complete copy of plaintiff's medical records from the other parties receiving the pre-suit notice. As a result of the plaintiff's failure to comply with the requirement to provide the doctors with a HIPAA-compliant authorization. Plaintiff's HIPAA authorization, as we reproduced in our brief, did not identify the persons authorized to make the disclosure of the medical records, nor did it identify the persons authorized to receive the plaintiff's medical records. Your Honors, there is no dispute. There's none in the record, none is asserted in any of the briefing, that the plaintiff's authorization was defective. And under the Martin standard, the defendants have met their burden by challenging plaintiff's compliance with Section 121. The record in this case demonstrates that the only records that Doctors Arthur and Sorensen had access to were their own records. Again, they did not have access to and no way of accessing the complete records from each other provider being sent the pre-suit notice as required by Tennessee law. The plaintiff here did not and could not prove that the defendant doctors were not prejudiced by the plaintiff's noncompliance. The trial court properly dismissed Doctors Arthur and Sorensen from this matter, and respectfully, this court should affirm the trial court's judgment dismissing the defendant doctors from this case. Those are the remarks I have prepared, and I'm certainly glad to take any questions from the panel.
Thank you, Mr. Joy. Do we have any questions? Hearing none, that concludes the oral argument. Before we close, let me add that the court will enter an order granting Mr. Tooten's motion to withdraw and stating that no one had made an appearance on behalf of the appellant, and there had been no motion requesting a continuance of the oral argument. And for that reason, and based upon the statements of counsel for the appellees that they desired the opportunity to present their oral argument and they felt that that was in their client's best interest, we decided to move forward with the oral argument. With that said, we'll take this case under advisement and render a decision in the near future. Mr. Hibner, you may close court.
This honorable court is now adjourned.
Thank you. Counsel, you're excused.
Thank you.